Good evening, everyone. Welcome to the master program Religion in Society, Culture and European Integration that is organized by the University of Belgrade in cooperation with several faculties of the university. Some of them are also faculty of law in Belgrade, faculty of theology in Belgrade, faculty of philosophy, and some other faculties. Today's lesson will be dedicated to the issue of the presence of religious symbols in the public sphere and the secularity of the state, particularly in the Republic of Serbia. Firstly, I would like to express my gratitude to the Ferenc Mádl Institute of Comparative Law, which is the initiator and coordinator of the Central European Professors Network. This network has been established with the main intention of creating a scientific community of jurists from Central European countries, which be representing the peculiar approach of Central European jurisprudence to current legal science topics. The network consists of several research groups, and today's lesson is a result of the research that I conducted as a member of the research group responsible for the topic freedom of religion and conscience. Of conscience and religion. As you probably could notice, religious symbols are present all around us, in your classrooms, in public offices, in courtrooms, sometimes in mass media, also in hospitals, state flags, public transportation, and etc. It could be said that wherever there are people, there is some symbol with religious roots. For the purposes of this lesson, the term religious symbol will be used for symbols which are linked to or inspired by a religion or belief. Also, the meaning of the term public space should be understood in the broadest of terms. It includes state and public institutions and all spaces outside the private sphere and inner domain of religious organizations. The presence of religious symbols in the public sphere is based not only on constitutional principles, but also on the social values on which the modern legal system in the Republic of Serbia is based. Some of those values, we will talk about them today, are history and tradition. Religious symbols are deeply rooted in the history and tradition of the people living on the territory of the Republic of Serbia. Significant state and national holidays are at the same time religious holidays. Their celebration is connected with the performance of religious rites, with the inevitable use of signs or symbols of particular churches and religious communities. The second important characteristic of modern Serbian society is religious pluralism, but autochthonous religious pluralism. In general, pluralism is immanent to a democratic society. The origin and survival of the democratic society depends, among other things, on religious pluralism. One of the forms of manifestation of autochthonous religious pluralism is the public presence and the use of religious symbols of traditional churches and religious communities. This is not this not only protects the right of traditional religious organizations to express religious beliefs, but also contributes to the democratization of a modern framework of state-church relations. Since religious and ethnic affiliation are often intertwined, the protection of religious pluralism contributes to the development of harmonious inter-ethnic relations and is especially important for improving the position of religious and national minorities. The Republic of Serbia stipulates that no religion may be established as a state or mandatory religion, so-called establishment clause. The ban on the establishment of a state church actually opens the space for religious symbols of all religious organizations to appear and to be used in the public space in the broadest sense of the term. Of course, the factual differences among them have the consequence that traditional and the largest religious organizations get the most space in the public sphere. The presence of religious symbols in public space does not violate the establishment clause because in that way the state religion is not established. Also, the fact that a religious symbol of certain religion is used in state and public spaces does not determine the status which that religion or religious organization has in a legal system. Otherwise, the representation of, for example, Lady Justice in courtrooms around the world would mean that the Roman religion has the status of state religion in many countries, and that is far from the truth. The principle of protection of freedom of religion also is one of the principles of constitutional principles. The Serbian constitution affirms the principle of religious freedom of every person and the principle of protection of collective religious rights. This freedom includes the freedom to manifest religion or belief. The Constitution guarantees the right to freely express religious beliefs in its collective and individual aspects. Thus, the use of religious symbols in the private or public as one of the ways of expressing religious beliefs enjoys constitutional protection. Of course, freedom of expression of religious beliefs makes sense only if it is guaranteed both to individuals, that is guaranteed to individuals, to churches, and religious communities, religious organizations alike. Freedom of religion in its external aspect, forum externum, is not an absolute right. Any restriction of this right in order to be allowed must meet the conditions prescribed by the Constitution. As you can read, freedom of manifesting religion or beliefs may be restricted by law only if it is necessary in a democratic society to protect the lives of and health of people, morals of a democratic society, freedoms and rights guaranteed by the Constitution, by the Serbian Constitution, public safety and order, or to prevent initiating or of religious, national, and racial hatred. Those provisions are probably well known to you because similar provisions are contained in international human rights instruments from which they are taken. These restrictions are necessary in order to prevent possible abuse. There are religious symbols that are manipulated and instrumentalized by various extremist organizations and movements. In order to prevent the possibility for members of such organizations under the veil of protection of their freedom to manifest religious beliefs to promote their organizations and mislead the public, it is necessary to establish certain restrictions. It is important to emphasize that these restrictions on the freedom of religion are in line with the international standards for the protection of human rights and freedoms. The Constitution of Republic of Serbia does not explicitly provide that the state may cooperate with churches and religious communities. Since such cooperation is not explicitly prohibited either, the prevailing view is that cooperation between the state and the church, which does not violate the principle of secularity of the state, is not unconstitutional. In order to understand a certain model of the relationship between state and church, it is necessary to connect it with other models that are implemented in other states and legal systems. Isolated observation of only one model does not provide a complete picture of its theoretical and practical implications. However, the fact is that there are certain tendencies that are noticeable in the field of state-church relations in modern European countries. New challenges faced by European legislators, as well as the constant progress of the doctrine of state-church relations, have radically changed the classical view of the relation of state-church relations. First, each classification, as you can see on the presentation, has more theoretical than practical significance. When regulating the relationship between the state and the church, the legislator is not guided exclusively by the selected specific church, but generally takes into account a number of other factors. One gets the impression that adherence to a certain pattern is actually a rarity, and that it appears mainly in the states where there are some of the more, let's say, extreme models of church-state relations, such as the state church or systems of absolute or strict separation of state and church. Most classifications are based solely on a normative approach without a broader interdisciplinary study of the relationship between the state and the church. When speaking about the model of the relationship between the state and church in certain state, it is necessary to refer to the religious, cultural, and demographic facts and circumstances in which the specific model is applied. Only on the basis of that broader insight, it is possible to draw concrete conclusions about the model that is being applied and, which is more important, for the relations between the state and the religion this model produces. Another important fact that should be mentioned is that today in Europe there are no pure models. There are no states that consistently respect only one theoretically defined concept of the relationship between the state and church. The reasons can be found in the complexity of modern relations between religion and state, and the challenges that European states face, and which are the consequence of political changes in the east of the continent, and the change in the religious structure of the population in the west of the continent. In addition, the dynamics that generally characterize changes in European societies impose a creative and innovative approach which cannot be limited to theoretical concepts. One of the reasons why pure models do not exist is the tendency of convergence of different models. The states that have been known church or established church in recent decades recognize a certain autonomy to the established churches, while the system of separation in the system of separation, there is an increasing development of the cooperation between the state and the religious organizations. This is especially clear from the difficulties that authors face when trying to identify and theoretically explain the differences between different models. The convergence of different models progressively leads to the creation of a unique European model of state-church relations. Although there can be many objections to the idea of creating a European common model of church-state relations, the fact is that thanks to international standards for the protection of religious freedom, which are respected by all countries, national laws regulating the position of religious organizations on the European continent are brought closer. According to the classical tripartite classification, all the systems of relations between the state and the church belong to one of the following models, of the following three models. As you can see, those are the model of strict separation, the model of state-church, and the model of cooperative separation. A system of cooperative separation could be defined as a system in which the constitutional principle of the separation of state and church does not represent an obstacle to achieving their cooperation in different domains. In this system, the scope of cooperation is not specified by the Constitution. It does not belong to materia constitutionis and may vary depending on different circumstances. States have been allowed a wide margin of appreciation when determining the specific areas in which they will cooperate with the church, as well as the manners in which that cooperation will be realized. The state has a benevolent attitude towards religious organizations and recognizes their positive role in the development of democratic, pluralistic societies. This system of relations between the state and the church is accepted in the vast majority of European countries and can be said to represent the expression of European Christian values in the modern age. The law which regulates the status of churches and religious communities in Serbia, as well as all regulations which regulate the exercise of their rights in various domains, are based on the principle of cooperation between the state and church. This cooperation is realized in the various spheres and areas. One of the consequences of that cooperation is certainly the presence of religious symbol in public and state institutions in which it is realized. For example, conducting religious education in public schools of didactic aids which as a rule contains religious symbols and signs of certain religious organizations. Another example is the Electronic Media Act, which provides media space to churches and religious communities. This paved the way for the use of various religious symbols in the programs of public media services. Thus, the application of the principle of cooperation between the state and churches and religious communities in the Republic of Serbia has indirectly contributed to making the presence of religious symbols in the public sphere more noticeable and to expanding to all the areas in which the state and the religious organizations can cooperate. The Constitution of the Republic of Serbia prescribes the prohibition of discrimination with an explicit prohibition of discrimination on the ground of religion. The question may be raised whether the use of certain religious symbols in public space discriminates against all other religious organizations that do not identify with those symbols. All religious communities are equal, and Serbian legislation regulating the cooperation between the state and the church does not differentiate between different religious organizations. However, in practice, there are reasonable limits in exercising the rights of all religious organizations, in the sense that not all the symbols of all existing registered and unregistered religious organizations can be present at the same time and to the same extent in the public sphere. Such factual and reasonable restrictions do not represent discrimination, since it is not a matter of unequal regulation of similar situation. In addition, factual differences between religious organizations have the consequences that interest of the public is not the same for all churches and religious communities. In that sense, it is completely logical that religious symbols of traditional churches and religious communities, to which the largest number of citizens belong, are more present in the public sphere in relation to other religious organizations. It is important that there is no regulation that legitimizes such a restriction and which would make religious affiliation the basis for discrimination against certain religious organizations and their members or followers. In connection with the previous principle of non-discrimination, there is the principle of equality of all churches and religious communities. The Constitution states twice that churches and religious communities are equal. As in the case of the principle of discrimination, the question may be asked whether the use of religious symbols of certain religious organizations violates the principle of equality of all religious organizations. It would be difficult or probably extremely impractical to use always the symbols of all existing religious organizations in public sphere. That shows that the most of usually the traditional churches and religious communities and their symbols are present in public sphere. It is important to point out that regulations does not make any difference between traditional and non-traditional churches and religious communities, and do not prescribe any restrictions of the use of religious symbols of non-traditional religious organizations. Finally, the distinction between equality and identity should be underlined. As Professor Gerhard Roberts observed, the safeguard religious liberty, the correct paradigm to safeguard religious liberty, the correct paradigm is not identical rights. Identical rights would preclude a multitude of manifestations of positive religious freedom. The principle of sorry for this interruption. The principle of the secularity of the state is one of the main principles on which the regulation of the relations between the state and the religious organizations in modern democratic states is based. When it comes to the Republic of Serbia, it is specific that the principle of secularity is one of the constitutional principles. Namely, in the first part of the Constitution of the Republic of Serbia, which contains constitutional principles, that Serbia is a secular state. The question that arises is whether the presence and display of religious symbols in the public sphere violates the principle of secularity of the state prescribed by the Constitution. In that case, is the manifestation of religious beliefs and the presence of religious symbols in the public unconstitutional? In order to give a clear answer to these questions, it is necessary to define first the concept of secularity. There is no generally accepted definition of this term in the literature. Most authors try to use a comparative method to deduce certain regularities from the example of several secular states. However, the ways in which the status of religious organizations and the exercise of the right to freedom of religion are regulated in secular states vary widely. It could be argued that the states with state religion are all alike. Every secular state is different on its own way. It is breadth of the notion of secularity that allows different states to adapt their legislation on churches and religious communities to their own historical, social, legal, and religious circumstances. This is also the reason why there are as many definitions of secularity as the authors who have dealt with this issue. There is also the view that the notion of secular state, due to its polysemy and the impossibility to determine its precise meaning, is not adequate constitutional term. There are a number of different definitions of secularity, secularism, and secularization in the literature. This can be seen from the fact that the constitution of only a few countries in the world contain the adjective laïque or secular when they talk about the character of the state, looking mainly up to France and Russia. The existence of such a term in the Constitution of Serbia has led to the formation of specific secular fundamentalism, which is advocated by certain NGOs and human rights activists. They are of the opinion that in secular state, no interference of religious organizations in a public sphere is allowed, and no impact of religion in social issues is acceptable. Such secular fundamentalism is in its essence closer to the socialist or communist reality from the second half of the 20th century than to the meaning of the term secularity in modern democratic states. The fact that the secularity of the state is a constitutional provision cannot be an argument in favor of its fundamentalist interpretation, according to which secularism implies the hermetic separation between religion and public sphere and isolation of religion in the private sphere. In order to understand better the issue, it would be useful to underline the terminological difference between secularity, secularism, and secularization. Brett Scharfs explains this in the following words. Both secularity and secularism are linked to the general historical process of secularization, but as I use the terms, they have significantly different meanings and practical implications. By secularity, I mean an approach to religion-state relations that avoids identification of the state with any particular religion or ideology, including secularism, to provide a neutral framework capable of accommodating a wide range of religions and beliefs. By secularism, in contrast, I mean an ideological position that is committed to promoting a secular order. The difference between these two terms as two antipodes has also been developed by the Roman Catholic doctrine. According to it, secularity is a principle of distinction between church and state, and secularism, a negative conception of separation between church and state in which the church is persecuted or denied its basic rights. Thus, the secular character of the state guaranteed by the Constitution does not mean that the state identifies with secularism as an ideology. On the contrary, in a secular state, secularism can only be one of many competing ideologies. This means that the manifestation of religious beliefs in the public sphere is not unconstitutional in a secular state. Quite the opposite. The presence of religion and religious organizations in public sphere is desirable because it is a natural space for acting of a religion and religious communities, and the space in which, through confrontation with competing ideologies, religion gives its contribution to the development of a democratic and pluralistic society. There are some uncertainties about the meaning of the term secular state contained in the 2006 Constitution of Serbia, and those were resolved by the Constitutional Court, which in deciding on proposal for determining the unconstitutionality of the law on churches and religious communities established that these constitutional provisions by themselves do not imply the system of this complete separation of the church and state, but that there is no state church and that there is no identification of the state with a particular religion or religion in general. Since the manifestation of religious beliefs in public and the presence of religious symbols in the public sphere, do not establish a state church or religion, nor does it identify the state with a particular religion, it can be argued that such practice does not violate the constitutional principle of the secularity of the state. In connection with the already mentioned principle, there is a principle of separation of the state and the religious organizations. It is explicitly stated in the Serbian Constitution with the following wording: church and the religious communities shall be separated from the state. Although the Constitution stipulates that the state and the religious organizations are separated, it does not specify which type of separation is in question, strict or cooperative. Anyway, the presence of religious symbols in the state institutions and in the public spaces certainly does not lead to the establishment of institutional unity between the state and religious organizations. Therefore, it does not represent a violation of the constitutional principle of separation of the state and the churches and religious communities. In support of this position is the fact that symbols and signs of various associations, humanitarian organizations, political parties, etc., are used in the state and public spaces, while there is no institutional connections between the state and those entities. And what should we conclude from everything said until now? Firstly, the use of religious symbols in the public sphere within the legal order of the Republic of Serbia is not regulated in detail. In practice, religious symbols are often present in the public sphere mainly as a result of informal initiatives of religious beliefs. Although there were individual attempts to limit the use of religious symbols in public, they did not receive a court epilogue, nor did the legislator intervene by amending existing legislation. Several different situations generate ardent controversies related to the presence of religious symbols in the public sphere. The first one is the presence in the public sphere of symbols that most of the citizens perceive as exclusively religious, such as icons, crucifix, status of saints, and etc. These symbols are often present in the public space not only because of their religious meanings, but also because of the broader historical and cultural significance they undoubtedly have. The presence of such symbols in public space should not be mandatory, but neither it is feasible to leave it unregulated and open to potential abuse. The law should prescribe the conditions under which symbols with among religious dimension can be used in public space. It should be specified which are the authorities that decide on that and how their decisions are implemented. This is especially important when we are talking about public offices, educational institutions, hospitals, but also companies in general. The law should also prescribe under what conditions the use of such symbols may be restricted and what the limits that the competent authorities must respect are. This is necessary due to the frequent misconception that their presence in the public sphere violates of secularity of the state. The second is the issue of wearing religious symbols in public spaces, like courts, schools, universities, etc. In the Republic of Serbia, no disputes were arising from wearing religious symbols of specific clothing that reveals someone's religious beliefs. However, this area should also be legally regulated. Certain religious practices may conflict with applicable law. Besides, European practice shows that a certain way of dressing can be prohibited even if it is a manifestation of faith or belief. Here, the legislator should apply a balanced approach by restricting the wearing of specific clothes or symbols according to the practice of certain European countries and the European Court of Human Rights, but at the same time leaving space for expressing religious beliefs through religious symbols that do not disrupt the harmonious life of citizens. The third controversy is the compatibility of the practice of construction of religious symbols and monuments in public spaces that have been financed by government, local authorities, or state-owned companies with the principle of secularity. In recent years, the practice of building various religious symbols in public areas has been noticeable. It is most often about building cross symbols, chapels, public fountains with decorations that have religious significance, and etc. In academic discourse, such practices are marked as a form of desecularization of public space. However, such facilities do not serve only religious purposes. It is an expression of the culture and identity of the vast majority of citizens of the Republic of Serbia. The law should regulate the construction of such facilities, taking into account the neutrality of the state and the equality of all religious organizations. At the same time, when drafting urban plans, competent authorities should take into account not only religious buildings, in the sense of the law of churches, law on the churches and religious communities, but also religious symbols and their visibility. That is the reason why, in addition to all mentioned religious buildings in the law on churches and religious communities, religious symbols should be included in this law. Lastly, but most importantly, there is a question of whether the manifestation of religion or beliefs in public space is constitutional, or more precisely, whether religious services and ceremonies that include the use of different religious symbols and have been performed in public or state institutions violate the principle of state secularity. The answer to this question had been formulated by the Constitutional Court of Serbia, which assessed that worship in public buildings serves to meet the needs of individuals who use the services of these institutions and does not violate the principle of separation of state and church. It is noticeable that, however, that many public institutions did not prescribe in their acts the possibility of performing religious rites at the request of the users of their services. Although they can the users can refer directly to the law, it would be desirable for internal acts to provide for such a possibility so that a larger number of users of services of public institutions would be aware of their rights and how they can exercise them. In the Republic of Serbia, there are no regulations that explicitly prohibit the use of religious symbols. Unlike some European countries, the Republic of Serbia has no regulations that restrict the right to wear specific clothes or symbols that are related to one's religion affiliation. Since the bans in the European countries are mostly related to non-Christian religious minorities, one of the reasons for this difference is probably the autochthonous religious pluralism. Religious minorities in the Republic of Serbia have been placed on its territory for centuries and generally share similar social values and culture. Although no discussions on the use of religious symbols in the public sphere could be heard in the Serbian courts, such debates are part of academic and public discourse. I'm sure that the engagement of the research group responsible for the topic freedom of conscience and religion will be a significant contribution to that public and academic debate. Once again, I would like to express my gratitude to the Ferenc Mádl Institute of Comparative Law from Hungary, and thank you all for your attention and for your participation. If you have any questions or any comments, feel free to share them with us.